please the court, I'm Dave Domina. I'm here on behalf of all of the appellees, Jacobs Cattle Company, Ardith Jacobs, and Dennis Jacobs. I think there's a predicate legal issue that has been identified already this morning that's worth talking about before we get to the facts of this case. And that is where there are competing remedies available to solve a problem in a partnership, a general partnership. One remedy being dissolution and the other being disassociation. Can the trial court elect which of those remedies is appropriate under the circumstances? Our answer is that the Partnership Act provides guidance for the trial court and this court. It does so by permitting some of the partners, more than one, who do not want to terminate the partnership to continue it in operation. In this case, Ardith and Dennis Jacobs made an affirmative election in writing and served it shortly after the lawsuit was filed, notifying the plaintiffs, the appellants here, of their desire to continue to operate as partners. They owned 79% of the partnership and still do. The partners who want out took the position that the entire partnership should be dissolved, all of the land should be sold, all of the tax should be paid, they should get their money out, and the 80%ers should not have an opportunity to continue to operate as mother and son. There's nothing in the statute to suggest that's either a preferred remedy or an essential remedy or an equitable remedy. In this case, the argument is that grounds for dissolution were proven. We concede that. We also contend that grounds for disassociation were proven and that it was the better remedy.
Do you think grounds for disassociation were proved with respect to James, who was not obligated on the lease and therefore couldn't have been delinquent in rent?
I agree. I do think they were proven, Your Honor, and I think that dissociation grounds were proven with respect to James because I must parse the observation in your question. It is true that James did not sign Exhibit 85, the lease. It is also true that James operated the land. His wife testified that he was the farmer. So he had the obligation to care for the land, which I think includes within it the obligation to see to it that the land owned by the partnership is used to meet its obligations to the partnership. That was a fiduciary duty that accompanied his partnership status, and he didn't meet it. He was actually sued and dismissed in the county court proceeding in which there was a judgment rendered against his wife for failure to pay the rent. The other thing that he did was to bring this case, and in the course of bringing this case, support the activities of the other plaintiffs who pledged their partnership interest on a bank loan contrary to the precise terms of the partnership agreement, and so he supported their breach of the partnership agreement as well. In this case, the simple remedy is that 22% of the partnership interests want out. There's plenty of land, there's plenty of money. Valuation was easily accomplished, and the payout is easily accomplished. There is no disadvantage here.
Do you agree with Mr. Nelson that the payout to the, I'll call them the dissociated partners, would be the same whether the remedy was dissociation or dissolution?
Yes, Your Honor, I do think that it's precisely the same. I think Mr. Nelson may not have reached what I believe was his point, that he thinks there would be a difference between the characterization of the gain on the sale of the farmland. His brief suggests that one element of his remedy is that he thinks that the farmland should be treated as sold and that all of the gain between its cost basis and its actual marketing price should be treated as profits and distributed as profits, since in this partnership, capital interests and income interests are different by definition under the agreement. We don't see that the statute makes that distinction at all, and we cited a number of cases, I think in paragraph 71 of our opening brief, that indicate that other courts in other jurisdictions have dealt with that issue and not adopted that point of view. You decided a case in 1956 in which I must give the plaintiff's lawyer credit for ingenuity, in which a life tenant sued the remainderment, claiming that the gain in the value of the land should be held against the remainderment. And that's in the nature of the argument made here. We think the trial court got the solution to the problem right, with one exception. And that is that the statute providing for dissociation is very clear about the date of valuation. The date of valuation is the date when the act that gives rise to dissociation occurs. This case was filed in 2005. That act occurred in 2005. The value of the land should be determined as of 2005, and the statute provides that the dissociated partner no longer participates in profits and only gets interest on the value of the dissociated partner's partnership capital. In this case, that makes a fairly significant difference because of the rapid rise in the value of land. Exhibit 109 is evidence of the value of the land in 2005. It's about 60% of the value found in 2012. And we think that the trial courts should be reversed for the sole purpose of correcting that valuation amount. Interest should be awarded. We adduced evidence of the interest rate, the judgment interest rate in Exhibit 111. That narrows that gap considerably because we have a 7-year time period involved, but it appears to us that that is the correct way to administer the statutory remedy. Thank you very much.
Does Mr. Nelson have any time for rebuttal? We are adjourned. Thank you.